Hello, everyone, and welcome to Internet Law Review. For today's story, we are covering Justice Kavanaugh's testimony to the United States Senate, and we're covering with an eye towards the question that has been circulating in the press as to whether or not there's any aspect of his testimony that could be considered perjury under the law. So we're going to be looking at this particular section of his text where he's describing things that appeared in his yearbook, because this seems like the section that people are most focusing on with respect to this question. So first, let's look to the law, and then we can discuss whether or not there's anything here that would meet the definition of perjury under the statute. So the statute that we're going to try to interpret today is 18 U.S.C. 1621. It should be noted that there is a section of the law, 1623, that also deals with perjury, but 1623 deals specifically with perjury before a court. And this is not before a court. This is a more broad provision of perjury. So 1623 does not apply. 1621 is the only statute that could apply with respect to perjury. And I've highlighted the most operative text here. The person who's taken an oath who, willfully and contrary to such oath, states or subscribes any material matter which he does not believe to be true has committed perjury. So we need to look at each and every word of the statute because each word means something that's critical. So let's start with the very first word in this statute, which is the word willfully. The word willfully is what's called a mens rea requirement or mental state requirement. Most statutes in the law require two things. They require a particular mental state and a particular action. It is usually not sufficient just to show action. You also have to show some state of guilty mind. And this is probably for the best because there are a lot of things which by their pure action might be illegal, but a person might do accidentally or without any design to do. So what we're really interested in when we're trying to decide if something is illegal is whether or not they have a guilty mind, whether or not they did it with a purpose or desire of breaking the law in some sense. There are four traditional mens rea requirements. Starting from the least to the highest, the least would be negligence. Next up is recklessness. Next up is knowing. And at the very top of the list is willful or purposeful intent, as it's sometimes called. To show willfulness, you have to show that a person not only knew that it would occur, but you have to show a specific intentional design that the result would occur. So to show that someone did something willfully is to say that they did it with a specific intent of causing the particular result to occur. So obviously this is a very high bar indeed because it requires a conscious design to break the law. So willful is very difficult to show, but that is the standard that is here. The next element that is relevant to our analysis is the term material. It has to be with respect to a material matter. And you might want to know, what is material? Well, material just means anything that might influence the fact finder with respect to the substantive issue that they're trying to decide. It doesn't actually have to create that result. It just has to be likely to incur that result. And here, because the issue at hand is whether or not he would be elevated to the Supreme Court, pretty much anything is material. There's not really a viable argument to be made that there's anything that's not material, because anything could potentially influence the fact finder with respect to whether or not he should get his position on the U.S. Supreme Court. So there's nothing likely that I can see that would be non-material with respect to this particular subject. But there are some circumstances where a person is testifying where they could theoretically lie about something that's completely ancillary that would be not material, and that would not be perjury under the law. So here, materiality is pretty much a foregone conclusion, so I don't think that's really a point that we have to worry too much about. The next and final piece of this is that he does not believe it to be true, meaning he has to know that what he's saying is not true, or he has to at least believe that it's not true. He has to believe that what he's saying is false. So it not only has to be false, it has to be something he believes to be false. It has to be something he is consciously, deliberately choosing to say, even though he believes it to be the contrary. So mere falseness is not enough. You have to show that he believed it subjectively to be false. Each one of these elements that are listed here is an element that would have to be proven to a jury beyond a reasonable doubt. So to find a charge of perjury, you'd have to show each of these three elements beyond a reasonable doubt to a jury. So let's look back at the text and see whether or not we think it's likely that there can be with respect to any of these. In this particular context, Judge Kavanaugh, now Justice Kavanaugh, is being asked to testify about things that appeared in his yearbook with respect to his name. So in this yearbook, there was a section that gave a name, and you were allowed to list clubs, activities, and so forth. And there were some elements that were listed under his name as part of his clubs, activities, associations that the U.S. Senate wanted to know about. Three in particular: the term boofed, the term alumnus as it related to the Renata alumnus, and the term Devil's Triangle. So in each of these three examples, Justice Kavanaugh gave a definition that is not the standard definition or well understood definition of the term. So there has been suggestion that he lied. Now, you'd have to show a couple things to show this. And this is actually going to the heart of the question in some senses too. You have to decide whether or not he was lying and whether or not he knew that he was lying and intending to lie. So the first thing that you might consider is that he had a idiosyncratic definition, that he had a specialized definition of the term. So it's not really sufficient to show that these terms have a well understood meaning or a common meaning that is well understood. You'd have to show that he had a particular meaning, because this goes with respect to something that appeared in his yearbook. Now, you don't have to merely take his word for it. It's not something that you just have to look and see, well, if he says it, it must be true. That's not sufficient. You look at the entire context of the thing. But it does go to the question of when he used these terms in his yearbook in the 1980s, did he at that time have a specialized meaning for these things that perhaps is not the standardized meaning? Did he use these terms as sort of a tongue-in-cheek joke with perhaps knowledge that it referred to some things, but he didn't use it to mean that he had done those things? He used it as a spoof or as a gag or as a specialized meaning. And that is a question that would be difficult to prove before a jury. To really show that, you'd have to show someone who knew him at the time, who knew that what those terms were and could testify that those terms were used with a particular sense or a particular idea in mind. And that's going to be obviously pretty difficult to show. You know, it's not just enough to show that the dictionary says something or Urban Dictionary says something. You'd have to show that he subjectively intended the word to be used a particular way, and that 35 years later, he's now saying the word means something that he didn't intend it to mean at the time. And I think that's very difficult. Now, is it possible that these terms have their more common understood meaning? Sure. I mean, when you normally use a word, you use it with a common understanding in mind. But it is possible that he had an idiosyncratic definition in mind when he used these terms, or that he used them in a way that is not typical. And so, did he commit perjury or not is a question I'll leave to you. Again, it would go to three. There would be a couple things you'd have to decide. You'd have to decide that he believed at the time he uttered it that these things were false, referring to what he said 35 years ago. So you'd have to believe that when he was testifying, that he knew 35 years ago these terms meant something different than what he referred to. So, and you'd have to show that he was stating it with a deliberate intent to deceive. So I think it would be very difficult indeed to show a perjury charge. Now, it should bear in mind, because this is relevant, that if it ever came to the issue of impeachment, in impeachment, that is a political context, not a legal context. And so the standards that the United States Congress would have to show to try to impeach him are much lower. In fact, they're pretty much subjective. So whether or not he's guilty of legal perjury is one issue, but if the United States Congress wanted to impeach him because they believed he committed perjury, their standard is pretty much anything they want it to be. So you could make a very viable argument that regardless of the legal issue, the political issue is completely independent, and I think that that's right. So as to whether or not he committed legal perjury, I'll leave to your decision, but I think it would be very, very difficult to prove, especially to the beyond a reasonable doubt standard, all three of those elements. I think materiality is pretty much a given, but to show that he that he subjectively believed it to be false and to show that he intentionally was misleading the committee in these answers, I think that would be very difficult to prove, because you'd find it very difficult to provide evidence as to what he did or did not intend when he wrote these things 35 years ago. So I think the legal case for perjury is very thin, but the political case is as robust as the Congress wants it to be. So I hope this has been helpful. For now, my friends, until later, cheers. Bye.